What's up, everyone out there in YouTube world, social media world, the formerly cool place known as Facebook world? Welcome to another episode of Musings with MGL. I'm your host, as always, MGL. Today, I'm going to do a quick video on a very hot topic that a lot of people ask me about. As much as you know, I've said before in my videos, I am a criminal defense attorney and I practice a lot of Second Amendment law, Second Amendment defense law. And so one of the biggest things that I do these days is represent people in these red flag laws. Okay, so you ask, what's a red flag law? So I'm going to go into a little bit of that on this video here today. Red flag law, it's kind of that's a slang term for what is specifically known as a risk protection order. Okay, as I've said before, I'm based in Florida, so I'm going to give you a rundown of kind of how things work down here, but there's similar laws everywhere, and they're trying to pass it. They can't pass it on a national level because they can't have a federal red flag law. But what they can do is they can put the squeeze on lower states to do red flag laws, similar to what they did back in the day with speed limits and stuff like that. So, and the age for alcohol. They can't pass a federal law that says you got to be 21 to drink. But what they did was say that if you want federal money to build your roads, you're going to pass a state law that says you must be 21 years old to drink. And all the states did that because they want the big money from the federal government. So there's a way that they can do that on a federal level for red flag laws too. Unfortunately, our senator down here, Marco Rubio, is in favor of something like that. There's been a lot of other politicians who are in favor of that. But essentially, what you're talking about is a risk protection order, which means if you are a person who the government, basically law enforcement, your local law enforcement agency, it could be your city, your sheriff, whoever your local law enforcement agency is, it's a law that allows them to petition the court to take away your firearms on a temporary basis because they think you're a threat to the community. So it's supposed to pick up these people who are in kind of like a gray zone. So obviously if somebody commits a violent felony, you arrest them and put them in jail, you don't have to worry about taking their firearms because they're sitting in jail. If you have somebody who, for example, is crazy and a threat to themselves or others, you can do a Baker Act on them or mentally commit them into an institution. And under the federal law, once you do that, a person is prohibited from having firearms, so you can take your firearms away that way. What they believe was happening, and this happened after the Marjory Stoneman Douglas Act here, or the Marjory Stoneman Douglas shootout at the high school down here, that has kind of sparked most of this stuff, is they believe that there's this group of people who were kind of falling through those cracks. So they didn't necessarily commit a crime, so you couldn't lock them up forever and take their guns away. They weren't completely crazy or borderline with mental health and a danger to clearly Baker Act them. So they were falling kind of in the middle. They were people who were dangerous, showing signs of being dangerous, maybe making Facebook posts about firearms, waving things around at their neighbors, pissing off people at the local store, claiming that they have firearms, showing mental health instability at work, at school, because again, this had to do with a school issue. So what they thought was that there was this group of people who didn't fall into any other category that would allow them to take their firearms, but was showing signs that they were a danger to the community and may do something with a firearm, whether it be a mass shooting or something to their neighbor or a family member or whatever. But the cops couldn't do anything about it. They knew the person had guns. They believed that they were a danger and might use those guns, but they didn't have enough probable cause to arrest them on any criminal charges, and they weren't showing enough signs that they could be Baker Acted on a mental health thing. So these people were falling allegedly into this crack. So the cops basically said, and the legislature said after the Marjory Stoneman Douglas Act, well, we need to find some way to take guns from these people, because they believed that the shooter in that case, the kid who shot up the high school and killed all those high school students, fell into that crack. He had not committed any crime in there that they believed that they could prosecute that would make him a convicted felon or a domestic batterer or some other way of putting him on a no-gun list. He also was showing mental health issues, but he had never risen to the point where he had actually threatened somebody or himself that would allow them to Baker Act him. But they believed there were clear signs, and everybody acknowledges that. You go back and look at that kid's history. There were clear signs there that the kid was having some problems and that he might end up doing something crazy. And so they needed to find a way that they could take guns away from those particular people. And so they created what's called a risk protection order or a red flag law. What that means is local law enforcement, your local law enforcement, if they have somebody who they believe falls into this category, that is a danger, then they can file a petition with the judge and get basically an injunction, for lack of a better term, to prevent that person from having any firearms for at least a year. It's similar to like a domestic battery injunction or stalking injunction. A restraining order is a slang word for it, where a woman will go down and say, hey, this man keeps beating me up. I need a restraining order to keep him away from me. And the judge says, okay, you're not permitted to have any contact with her for a year. And during that year, that person can't have a firearm. So they basically created the same concept, but instead of a person, like a person on the street, a woman, a boyfriend, whatever, going in and asking for it because of a domestic violence situation, the police officer has to be the petitioner. So a law enforcement person has to contact the judge. They have to fill out a petition that says, we think this person is a danger. They have to lay out the reasons why. They have to list what firearms they think the person owns. They submit that person to a judge. If a judge believes that they've laid out enough stuff in the paperwork to warrant a temporary emergency injunction, they grant a temporary emergency risk protection order. That risk protection order says that you must immediately surrender all of your firearms to a judge or to the sheriff's department. Now, remember, you have no notice of this. You don't get a hearing. They don't send you a letter that says, hey, we're going to send this to the judge. You have a right to send in your own letter to the judge. This is all done what they call ex parte, which means between the cop and the judge. You have no idea it's going on. They don't have to tell you that it's going on. They go and they get this emergency order from the judge that strips you immediately of your Second Amendment firearm rights. They tell you to turn all your guns into law enforcement, and if you don't, it's a felony. And if the law enforcement thinks you have firearms that you're refusing to turn in, law enforcement can then get a warrant to now go into your home and seize all of your firearms that you didn't turn in. That happens, again, immediately outside of your presence, without your knowledge. You don't have a right to defend yourself. You don't have a right to stop it. You just get a knock on the door, sheriff's department, and they say, here's your risk protection order. Give us all your guns. That's it. Then you will have a hearing 14 days after they've already taken all your firearms. And at that hearing, you have the right to come in and present your defense and challenge what they're claiming are the reasons why they needed to take your firearms. If you win that hearing, then the temporary emergency risk protection order goes away, and then they'll be kind enough to give you all your firearms back. If you lose that hearing, that 2-week temporary one gets extended for a year. And during that year, you cannot possess any firearms. You cannot own any firearms. Or you can own them, but you can't possess them. So you can own firearms, and you can give all your firearms to Uncle Joe, and Uncle Joe can keep them in his house. Or you got to give them all to the sheriff's department, and they'll hold on to them for a year. When that year comes up, the injunction or the risk protection order should go away, and you get your stuff back. But if law enforcement at the 11th month mark thinks that you are still a danger to the community, they can file another one of those petitions to extend it for another year. And they can do that indefinitely. There's no limit on how many times it can be issued. So if an RPO, a risk protection order, is granted against you, it will be a minimum of 2 weeks up to the rest of your life. It could be. If you keep having whatever problems they think you're having, they can keep extending it every year. What happens with most of them is, if it is in fact a person who might have a temporary mental health issue or whatever, they're allowed to seek counseling. They can present proof to the court that their counseling is correct, and then at the end of the year, when it goes away, they can get their stuff back. There's a few other nuances in there about motions you can file to end it early, et cetera, but I don't want to get into too many of those details here. You need to consult a lawyer in your state to get all those specifics. But the most important thing is this is a mechanism. You don't have to be charged with a crime. You don't have to be Baker Acted into a Baker Act facility. I have had people that were Baker Acted by the cops, and the Baker Act facility said there's nothing wrong with these people and let them out within 24 hours, and yet the cops still got a risk protection order against the person, at least for the 2 weeks. And then when we went to the hearing, we can show all the documents from the Baker Act facility that says there's nothing wrong with the guy, and then he gets his gun back. But during those 2 weeks, guess what? You can't have your firearms. And if you're a person who doesn't hire a lawyer and tries to go in there and defend yourself by yourself, you will always lose, and then you will lose your firearms for a year. Because if you're unrepresented in a situation like that, they would just steamroll over you. The lawyers who represent law enforcement will steamroll over you. The judge is under no obligation to protect your rights or let you know what the rules of evidence are in court. So if you go into a court on one of these red flag risk protection orders, you will lose if you're by yourself. You need to hire a competent attorney wherever you live to represent you in one of these, and you need to take it seriously because, again, it's important because you do lose your rights, and you can lose them up for a year, and you lose them for even more than that if they keep going on and on. But again, the important thing is this is a way for the government. I know we're all pro law enforcement usually here, but I'm just going to use the phrase government then. It is a way for the government to take away your Second Amendment rights without you even knowing about it. They just do it behind your back without you having a right to defend yourself. They can come to your house and they can take your firearms, and you then have to prove that you should get them back. That is extremely unconstitutional in my opinion. There have been challenges to this red flag law filed by the NRA and other various Second Amendment organizations. So far, they haven't gone anywhere to warrant any major decision. But these things are scary. They are scary. It gives a lot of power to the government to come take away one of your fundamental rights without even giving you a right to defend yourself. You have to come in on the backside and argue to get your firearm rights back. It is a wholly fair and unjust area of law. It's completely unconstitutional in my opinion. I've seen it being abused by the law enforcement agencies where I live over and over and over again. They basically try and seek it against everybody that they can seek it against. They will not just admit that they did it wrong. They will go to court. They will try and enter into evidence, documents that are inadmissible. They will try and go on to hearing without witnesses that they think that they need. Their plan is to hit you with this, hope you don't hire a lawyer, steamroll over you at a hearing in front of a judge, and then get this injunction risk protection order against you for however long they feel like getting it against you. That's what their hope is. You can defeat that by hiring a competent Second Amendment lawyer in your area to represent you. So make sure that you do that. But that's red flag laws in a nutshell, ladies and gentlemen. Do some research on them. You can just Google red flag laws, risk protection orders. Again, they're trying to get it somewhat on a national level, but again, they can't do it there, but they can force the states. So you're going to be seeing more and more of these pop up around the country. There's quite a few states that have them now. We were one of the first down here in Florida, and unfortunately is a very big black mark on our Second Amendment history here in the state of Florida. So unfortunately it exists. Make sure that you know that it's out there. Make sure you know your rights. Make sure you do your research. Make sure you call somebody to represent you when you need help. But and support the organizations that are going to challenge these type of things, because they're only going to get worse. So that's it in a nutshell. If you have any questions about it, you can put it down in the comment below. Please give me a like. Please give me a share. Please give me a subscribe. I'm trying to hit 1,000 subscribers. I'm getting pretty close. Once I hit the 1,000 subscribers, I can throw a party and apply to try and get some YouTube ad money, which would be pretty cool. But really, I just want to grow the channel to provide some more important information to all of you out there on the Second Amendment and the Constitution and the laws that reflect it. So thank you for watching as always. And remember, stay safe, stay healthy, stay vigilant, and as always, carry on.